You have here views of the central courts in Paris, and particularly the Court of Cassation, Court of Cassation, that is at the apex of the system. But I want first to share with you this diagram that shows the overall organization of the courts in France. You can read it in different manners, horizontally or vertically. Let's start with the horizontal layout. You may see that you have actually a three-tier system with courts or tribunals at the bottom, trying cases, doing the first hearing. Then you have intermediate court of appeals, and at the top, what would be the equivalent to our US Supreme Court, though you see that there are two of those, as will be explained in a moment. If you look at things vertically, you see actually that there are two orders, two court systems that exist parallel to one another. You have on the left the ordre judiciaire, which is the ordinary courts, and on the right, administrative order or administrative courts. We will start with the administrative courts, a three-tier system, as you see, that is the blue. And let me get there, starting with the court that is at the apex, at the top of the administrative court system, the Conseil d'État, Council of State. The Council of State is the descendant of the King's Council that existed in the past. It has been rearranged during the Napoleonic time, having an advisory role. The Council of State is advising the executive on matters of law and must check before administrative orders are published and become the law, must check whether they are in conformity with the Constitution or existing legislation, which is a good way of eliminating situations where review will be needed. And the second task is administering administrative justice. Originally, at the Napoleonic time, there was only one court to do this, which was the Council of State. With the development of administrative justice, lower courts had to be created. And let me go back here, which are actually the Tribunal administratif here that I'm circling around. So you had, during a long time, the administrative tribunals and the Council of State. More recently, intermediate courts of appeal were added so that you have nowadays pretty much the traditional model of having lower tribunals, appellate courts, and a Supreme Court for administrative cases. What are the tasks now of these administrative courts? The first task, which is ever so important, is to review executive orders or administrative decisions when a plaintiff complains that there may be a violation of the law or of the Constitution. You have the French word for judicial review. I will stop pronouncing, reading these names in French, because when I have, it's a lot of editing then, when I have to work on the caption. That's the last one I will give, the recours pour excès de pouvoir. So This is done by the administrative tribunals and can be reviewed by the Council of State. But if you are actually challenging a national executive order, you may go directly to the Council of State. The next task is to deal with ordinary cases. What do I mean by ordinary cases? I mean cases where the plaintiff would be an individual or a business entity suing the French government, the central executive, or suing any public organization such as a region, a municipality, or any administrative body that may have been created under the law. But this time, you don't want a decision to be reviewed, but it is actually, you want money. You complain about a dysfunctioning of an administration. If you can prove that such administration is acting in a wrongful manner that caused damage to you, it will be the equivalent to a tort dispute, but where the defendant is a government agency. Another type of ordinary cases are situations or individuals being expropriated for a reason, for a public policy reason, for example, for building a new highway or developing or creating a new airport or creating schools or extending a university campus. If people complain about the amount of money that is paid as a compensation, because of course people being expropriated must be fairly compensated, you will bring that to the administrative court. An interesting point is that in France, administrative courts do not apply the civil code, but they develop their administrative law on a case-by-case basis. So there is an administrative jurisprudence that is developed in France on a case-by-case basis. A few words about administrative judges. They are senior public servants. They are actually, all of them, after law schools or even after studying political science, have to be admitted at the École Nationale d'Administration, a national school for administration that was created after World War II, that is actually training the most senior civil servants of the state. That includes diplomats, people who may become ambassadors, people who may be at the head of a region or at the head of a high administration, or may work as chief of staff for ministers, but also that includes administrative judges. They are appointed by the executive, which is a little bit controversial. You know, in the past French experience is that these people were directly appointed by the emperor and later on by the president of the republic. And the big question is, how can they be independent? How can they review the decision of these people, of government entities, if their status, if they are placed under the authority of the government? And that is what I'm going to call a French paradox, or maybe a French miracle. But the Council of State in France has very early on, already at the beginning of the 19th century, developed a pretty independent mindset. And these people were taking their task very serious, not hesitating to declare a decision of the executive branch illegal or unconstitutional. So the praxis, if you will, is great independence on the part of these judges. I will now explore with you the other side, and I go back to the diagram, the left block, the ordinary judiciary. which has also a vertical distinction between civil matters, cases where one individual or business entity sues another one, and criminal matters. Criminal justice is actually attached, if you will, to the ordinary judiciary. So let us have a look at these ordinary courts and the way they are staffed, and then I will describe them with more detail. Sorry for the back and forth with the slides. Most courts are staffed by career judges who are trained in another higher school, the National School of Magistrature, if I translate École Nationale de Magistrature. You first have to go to law school, get your law degree, and then by a very competitive exam, after a very competitive exam, you may be accepted in this court that is located in the city of Bordeaux. Once you graduate from this national school, you will belong to the judiciary. You'll be an independent judge. Of course, the Department of Justice has to appoint you to this or that court, but you have a status of independence. Actually, there is a superior council of the magistrature that must be consulted before every appointment, promotion, etc. And judges cannot be removed against their will. They have a more independent status, if you will, than judges in the administrative courts. France, nonetheless, has a few courts that belong to ordinary courts where judges are elected. And that includes the commercial courts and the labor courts that have this strange name of Conseil des Prud'hommes. Let me go back to the diagram to show you this. You have, and I should use different colors, you got the standard on the civil side, Tribunal de grande instance, Tribunal d'instance. Okay, the ordinary courts for ordinary cases, if you will, where you have these professional judges being appointed. But we have a few additional courts, like, sorry for that, I'm not very skillful using the pen. I like to see where my thing is. Okay, you see here the commercial court. They have existed a long time, as we discussed in the historical chapters. These commercial courts go a long way, and judges were elected by merchants among their peers. Of course, nowadays, in major commercial centers such as Paris or Lyon or Marseille, they will elect people who have a solid legal training, because commercial law has developed to a great level of technicity. But in smaller centers, they rather have people who don't know all that much about the law, but are trusted by their peers, and the clerk to the court is going to give them all the technical advice that they need about the law. The other place where judges are elected is the Conseil de Prud'hommes, the employment courts, where actually half the judges are elected by employers and the other half by the employees. And on these courts, you always have representatives of employees and employers in equal number. And in the event you get a tie, a judge from the ordinary court system is going to break, if you will, the tie. You will have an additional hearing, and this time with the possibility of having a majority. So with the exception of these two courts where judges are elected, all the others are appointed and enjoy the status of independence. We go back now to the ordinary courts. There we are. Coming back to the French Revolution, the French like collegiality. They like to have a bench of 3, even at trial level. We do not use jury. The jury system is very peculiar to the common law. There is one exception in French law. We'll get back to that in a moment. But as a rule, cases, or at least important cases, are tried by a bench of 3. The whole idea is that among these 3, you'll have a very experienced judge who will be, the presiding judge, and less risk of influence, of influencing, bribing, or call it whatever you want. The French system, which has been abusive, arbitrary at the time of the French kings, has become a very modern and reliable system. I'm not going to say that nothing wrong ever happens. France is having its problems like all Western countries, but this is really exceptional. You have nonetheless cases where the French like the decision to be made by one judge. That will include the family cases. It's too intimidating when you have a custody case or even a divorce case, especially when the spouses agree. Why having a bench of 3? It will be one judge not wearing the robe, but very often the hearings are happening in the judge's chambers rather than in the courtroom. But also for criminal cases, petty theft, or cases, where people are taken red-handed, and we have proceedings that can be, taken in a very, 24, 48 hours after the event. The decisions here again are made by a single judge. So, as I say, no jury system except with the Court d'Assises, which is the highest criminal court to decide what we would call here felony, and that we call crime in the French language. Another specificity of the French system is that you have a right to appeal of almost every judgment, except if it is really in a very, very petty amount of money. So there are 36 courts of appeal distributed on the French territory. In appeal, you can ask the court actually to reconsider the facts and the law. It's not only on a point of law. We can actually have a trial de novo. It's a review de novo. Parties don't always ask for this. Sometimes they limit the scope of the appeal, which is a way, of making more efficient. But if people are not satisfied the way the case has been tried by the trial court, may go up and have a second trial in the Court of Appeals. And final appeals go to the Court of Cassation, located in Paris. I will discuss that one in a moment. A few words about criminal justice. Criminal offenses are of 3 kinds under French law. The French Penal Code distinguishes felony, called crimes in French, that are tried by the Court d'Assises. The Court d'Assises is actually composed of 3 sitting judges, plus a jury that used to be a jury of 12, has been reduced to 9, and now we reduce it to 6. But there is a possibility to appeal, in which case that will be a jury of 9. So it is not exactly a jury system, but more of a mixed court with professional judges and lay jurors, if you will, and they deliberate together on the guilt and on the offense. But you see that the professional judges are outnumbered by the lay jurors. The system actually has been inherited from England because the French during the Revolution were fascinated with everything where you could have an element of lay justice. They did not import the whole thing, but at least have it for the most serious crime. We never have it in the civil disputes. You have then an intermediary category of offenses, misdemeanor, les délits, we use the word délit in French, which gave delict in the English language, and it is the Tribunal correctionnel having jurisdiction, correctional court, 3 sitting judges to make the decision, or sometimes 1 in the cases of people being taken red-handed and moved directly to the court. And finally, you have minor offenses, which are, if you will, regulatory offenses, and there are plenty of those. That includes lots of road traffic offenses or violation of zoning codes, etc., if you're building without permit, or again, during the COVID lockdown, if you were walking in the French street without signing your self-certificate, or if you were, or nowadays, if you don't wear the mask, that would be a contravention, as we call it. Typically, people pay the ticket. You know, you're issued a ticket and you pay. But if you protest, the case is going to be heard by a single judge in the police tribunal, Tribunal de Police, as we call it. Let me go back to the diagram so that you see where this fits. And I will again try to get this time using the blue color. I'll go from the bottom to the top. If I can see what I'm doing, I underscore the Tribunal de Police dealing with these regulatory offenses. Then you have the correctional tribunal, misdemeanor cases, and felony cases go to the Cour d'Assises, which has been placed here at the level of appellate courts, because actually the sitting judges are judges from the appellate court, but it can be a first trial of these felony cases, or it can be appeal of a Cour d'Assises that will be heard by another Cour d'Assises, and this time with a more numerous jury of 9 jurors. So I think we have explored, if you will, all these various courts, and you've read anyway the narrative in the course supplement. And of course, if you have questions, send me an email or we can talk about it. And I will finish the presentation with a few words about the highest court on the ordinary judiciary, or the ordinary court, the Court of Cassation, located in Paris. You have here a view of the Grande Chambre, the principal chamber of the Court of Cassation, all gilded on the Ile de la Cité in Paris. You have judges sitting, and you see attorneys wearing their robes. Okay, what is the Court of Cassation doing? It has been created in 1791, so during the Revolution, for France to have a highest court that it did not have, because you had multiple highest courts. Each province had one. The task, the roadmap for this court was actually to not to review cases that an ordinary court of appeal will do, but to review only on point of law, okay? They review the application of the law, not the facts. And the purpose, the very reason why it was created, the purpose is twofold. You want to make sure that the law is properly applied by the lower courts, and you also want to secure the uniformity of the application of the law, and particularly the uniformity of the interpretation of the codes and other legislation by the courts in the country. You want to avoid some courts of appeals to go one way and other courts of appeal going another way, just like here when circuits are split. So the task of the Court of Cassation is to maintain this uniformity. And the system is built as a pyramid, and this is the top of the pyramid, which indicates that rulings by the Court of Cassation are normally followed by the lower courts, but we will rediscuss this when we discuss the sources of the law and when we talk about jurisprudence. Another French specificity is that to appeal to this highest court, you don't have a cert system, you don't have a certiorari system. No leave to appeal is needed. It is a right given to every citizen or every organization or business entity. If you complain, if you believe that the law was not properly applied in your case, you may appeal to the Court of Cassation. That is inherited from the revolution, but you may imagine that it is causing problems because it brings many cases, and probably more cases than the court can handle up there. Yes, the figures are pretty high, dramatically high. Over 20,000 appeals are lodged in every single year. There was a time when we reached 30,000, but thank goodness the number has decreased a little bit. So ways had to be found to deal with appeals that are without merit or are simply frivolous. And these will be seen in a rather expeditious manner by panels of 3 justices who will in one afternoon, clean up the docket and actually reject appeals in many cases. And for the serious cases, not really called, for the attention of the Court of Cassation, they are normally dealt with by a panel of 5 justices. So that implies a pretty strong organization. The Court of Cassation, for already a few centuries, is composed of 6 chambers. You have 5 civil chambers and 1 criminal chamber, and the number of justices is very high. It's not 9 like we have at the federal level or 7 at the state level, but it's more than 100. It takes large resources to deal with these many cases. But we will get, when we discuss jurisprudence, we will see the mechanisms that are there to ensure that the system is more efficient. We're coming now to the end of this presentation. I just go back once more to the initial diagram. You've seen the 3 layers. It looks very traditional, just like the system that we have here, but we see, however, that things are working pretty differently, given the fact that appeals are quite routinely made, and it's so easy to bring cases all the way to the highest court in the nation. So thank you once more for your attention, and I will see you next time.